The recent Supreme Court decision, Fulton versus City of Philadelphia, is causing me to rethink the whole conservative philosophy of the court, the whole jurisprudence that we as Republicans, as conservatives, have brought to the court over the past 30 years, going all the way back to Judge, and legal scholar Robert Bork. I remember Bork very well. He was my neighbor at the American Enterprise Institute, and just a wonderfully witty, ironic, curmudgeonly fellow. At one point, I remember his research assistant comes in and he goes, I forget her name, but it was like, Sandy, I didn't see you at work yesterday. And she goes, Judge Bork, yesterday was Veterans Day. He goes, Sandy, are you a veteran? And she was like, well, this was Bork. He was gentle, but he could be rough in tone. But most importantly, he was the architect of this whole conservative way of thinking about the court. Things like, we got to look to the original intent of the framers. Things like the judge is an umpire and not a player. Things like the judge should respect precedent. Precedent creates a kind of legal authority. Things like we should defer to the legislature because judges, after all, don't make the rules in a democracy. The legislature makes the rules. The judges, in a sense, only call the plays. But all of this, I think, needs to be now re-examined, in part because even though conservatives have sort of dominated the nominees to the court, we haven't actually seen dramatic shifts in the conservative direction, really on any key issues. Even on the Roe versus Wade case that the court is taking up soon, the court is not looking at the foundations of Roe by taking a case, for example, the Texas heartbeat bill, which essentially says life begins at conception, or at least at the heartbeat. They're taking the Mississippi case, which is about whether or not abortion can be regulated after 15 weeks. Now, the victories of the left at the court are spectacular. Gay marriage. And when they have a win, it's kind of like a done deal. It's never reopened. It's almost like we now have to sort of just kind of reconcile ourselves to it. It's the left is able to move and create a milestone, and then it's almost like their victories are permanent. Our victories are always tentative and provisional and have to be fought all over again. And this latest case, Fulton versus City of Philadelphia, is no exception. So let's kind of get into the case. Now, it may seem odd that I'm doing this kind of re-examination of the court when it's a case that our side won. And not only won, but we won it 9-0. We got even the liberals. So think about it. We're talking about a case that's, by the way, not an unimportant issue. We're talking about placing children with gay couples in foster care. And the Catholic Social Services said, we're not going to do that. And the city of Philadelphia said, well, yes, you are. Otherwise, you don't get any government contracts. And both sides went to the court and said, you tell us whether or not the anti-discrimination law that protects gays can be used to force a religious organization, in this case Catholic Social Services, to kind of go against its teaching, go against its conscience, and do something that they are religiously prohibited from doing. So it's kind of interesting that we got even Sotomayor, we got even Kagan, we got Breyer, all on the 9-0 side of this ruling. Of course, the left has been complaining. Here's Representative Pramila Jayapal. This case isn't about religious freedom. It's about discrimination against LGBTQ plus families. Now, first of all, asserting something doesn't make it so. Obviously, the case does involve religious freedom, and it involves LGBTQ protections. And the real question becomes, which takes precedence? You can't just announce that it's not about this, it's really about that. This is not really about censorship. We're just basically preventing you from insulting people that we think should not be insulted. No, you can't just say it and it doesn't become the law because you said it. Now, in the case itself, I think the win here, and by the way, conservatives have been winning these religious freedom cases. I believe we have now had 18 out of 19 wins in a row, which is pretty impressive. And that is a measure of the fact that I think even the liberals on the court, even the progressives, the Democratic nominees, are taking the position that if somebody has a religiously informed position based on conscience, this is not a position sort of designed to be against anybody. It is a philosophy of the family. It is a philosophy of human dignity. It's anchored in centuries of teaching. And if this is a sincerely held point of view, then no, you don't get to come in and force them to go against those convictions, even if you have some competing, deeply held value. No discrimination against LGBTQ. That's fine. But what the court said is, what we're talking about here is making an exception for a religious organization based upon the Religious Freedom Clause of the First Amendment. So all of this is, good news for our side. But in the middle of this, there's a big problem. And that is that the court was reluctant to overturn the precedent-setting case, which is the Smith case. The Smith case, which goes all the way back to 1990, Employment Division versus Smith. This is the decision that basically said that you can force religious groups to act in conformity with what's called generally applicable laws. And certainly the Philadelphia law is a generally applicable law. It applies to everybody. No one's allowed to discriminate. And the amazing thing is that Smith decision was written not by some leftist, not by some liberal. It was written by Justice Scalia. And herein is the problem. So in the next segment, I want to take up the problem. How is it that the greatest obstacle to achieving religious freedom comes from what some people would say was the most conservative justice on the court? Doesn't this imply that there's something fundamentally wrong with conservative jurisprudence in general?